It's a discussion on sports law and some sports law issues. At the outset, I would like to acknowledge the traditional owners of the land on which we are meeting today, the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present. We have three speakers today. The first speaker is Patrick Knowles SC, and his presentation will focus on the strategic choices that arise in different forms of off-field disputes. The second speaker in our freewheeling tour of sports law is going to be my colleague here at Level 22, Katherine Hooper, who we generally know as Hoops. And Katherine will be discussing the governance of incorporated associations under applicable NSW legislation and the issues that can arise when disputes within incorporated associations and sports clubs sometimes end up in the courts of law. Finally, I will also make a little presentation, and it's likely to be me delving into a few self-indulgent war stories about my experiences appearing in sporting tribunals in respect of basically when players do the wrong thing on the playing field and what happens there. With particular, I've got experience in respect of the World Game, appearing as disciplinary counsel for Football Australia. Now, each of the presentations are unlikely to be lengthy, and we invite questions. If you are watching online, you can send your questions via the chat, and then Jackie Charles, our clerk, who will coordinate the questions, and at the end she can ask the questions on your behalf. So I'd like to introduce our first speaker. He's a guest here. He's not a member of these chambers. He practices at 10th floor chambers, just down the road from here. Patrick Knowles is senior counsel, and he has extensive practice in commercial and equity and public law, but also a significant practice in the sports law field. And he's been involved in a number of significant matters, including proceedings in the National Sports Tribunal concerning complaints brought against a former head coach of the Australian women's gymnastics team. I'm sure you all heard of the issues involving the Essendon Football Club some years ago, and the supplements concerns that were there and the matters that went on to ultimately to appeal to the Court of Arbitration for Sport. And he's also been involved in an arbitration relating to NRL player agents and disciplinary proceedings relating to breaches of the rugby league salary cap. He's been involved in another matters. I just thought I'd mention those few just to give a taste. Now, as I said earlier, Patrick will be speaking to you in connection with the strategic choices arising in different forms of off-field disputes. So I'll hand it over to Patrick now.
Thanks, Ivan. What I'm trying to do today, in the amount of time I have to speak with, won't be able to deal with anything in very much depth, and so I apologise for that in advance. But what I wanted to focus on was, if you are a sporting organisation, or you're representing a sporting organisation, or on the other side of things, if you are a player or a coach or an official, or you're representing as a lawyer one of those people, what do you do, especially in those first week or so, 2 weeks of dealing with a dispute? And so what I wanted to talk about is two types of off-field disputes. One is anti-doping cases relating to drugs in sport, and the other are off-field discipline cases, and especially issues involving member protection complaints, complaints about bullying, complaints about harassment within a sport and how they're governed. So, Jackie, can I ask to go forward a couple of... This is a good start. So, first, what do you do if you're a sporting organisation and you get notice of there's an anti-doping issue in your sport because, for instance, there's been an adverse test result for a participant in your sport? This is the easiest situation you'll probably ever find yourself in if you have a legal dispute involving sports law, because what sporting organisations have to do, and lawyers advising them have to do, is pretty clear in that outside organisations, Sport Integrity Australia, sometimes WADA, will almost always take the lead and just work with them, find out what they need from you, comply with it. There's not really a massive role for the sporting organisation, at least initially. There's a couple of things you should do though. Dealing with the last dot point first, you are going to at some stage have to find out some basic information, not so much about whether or not someone was taking drugs in sport or illegal substances, but whether or not that person is bound by the policies of your sport. And a lot of it is going to be very mundane kind of things. Are they officially registered with a club or a state organisation? Did they pay their annual renewal fees? When was the last time they participated in an event? Have they been actively training in an event? Those kinds of things are things that the anti-doping authorities like Sport Integrity Australia are going to need from you, so you may as well find them out. The other thing, and this is probably directed to the lawyers advising sporting organisations, is inevitably there will be someone in a sporting organisation of any great size. They'll probably have the title of media manager or communications manager, who will want to publicise something. They will want to say, we need to get out there. It'll probably have some meaningless cliche like, we want to get on the front foot, something like that. Just tell them to stop. There are restrictions on what can be disclosed in anti-doping matters and at what stage things can be disclosed. It's very heavily regulated. There are occasions where you can issue press releases. There are restrictions on what the content of the press statements can be. Just go back to point one, work with Sport Integrity Australia and WADA. Don't let your media and communications manager go off on their own, because problems do happen. Now, the flip side on the next slide is, what do you do if you're acting for an athlete or a coach or an official who's tied up or becomes the subject of an anti-doping complaint? Now, this is really hard because of a few things related to the legal principles, because it's a strict liability scheme, but also actually just as much related to kind of non-legal issues. It's hard because quite often the person, the subject of the complaint, will be subject to a provisional suspension. They may have lost their job or their way of earning money. They may not have a lot of resources in the first place. People who they previously considered their friends or someone who might be able to assist them might be unwilling to assist them, not through any sense of malice, but because they don't want to get associated with a drugs in sport complaint. It's just a very difficult situation. So especially if you're a lawyer for a client in that situation, just really be aware of all aspects of supporting your client. Make sure if they need it, they get psych help, or make sure they've got friends or family who can help them, as well as delivering on the law. The approach you need to take, and if we go to the next slide, does on the strategic issues, depends a bit on whether it's a what I call an adverse analytical finding, so a drug test result, or whether it's some other type of alleged violation. But if it's an adverse analytical finding, there's not much downside in seeking initially confirmation of a B sample test, because it may or may not confirm the result, but it's worth checking. The other thing that is really important to do is, as quickly as you can, as I said there in the third dot point, identify the source. And by that, if your client tells you, I don't know how this particular drug got into my system, work with them to try and identify the possible sources. One obvious possibility is if they're taking some kind of sporting supplement or some other kind of medication. But it's really important to try and identify that quickly, because the evidence that might help you might disappear quickly as well. So if it's a sporting supplement that you think might be the cause of inadvertent test results, the best thing you can do is ask your client, well, do you have any of that supplement left? Can we get it tested? Because that might be the difference between a 4-year sanction and a 2-year sanction. And you've got to move quickly. Or it might be getting information like medical records, prescription records that you just can't guarantee that in 2 years' time are still going to be there. The other thing that, just to put up there, two things, I won't have time to go through them all, is I say they're cooperation but not capitulation. It's a flaw, in my view, in the system, but there is very little advantage to someone charged with anti-doping violations to plead guilty, so to speak. That's the wrong language. I'm using the language of criminal law. But there's not, with some limited exceptions, there's not a system or tariff of discounting the sanction by reason of accepting your client has engaged in doping. But when I say cooperation is important, because there are ways of being able to reduce the sanctions that come about not through necessarily pleading guilty, but providing evidence that might establish a basis, for example, showing that you were not either at fault or not significantly at fault. And the evidence that, for example, an anti-doping body might require to establish that might depend upon the degree to which you cooperate. There's also a provision, rarely used, but there is provision for WADA, the World Anti-Doping Agency, to approve a case resolution agreement whereby some other sanction other than the mandatory ones are imposed. So there is scope for cooperation, but do it carefully. And consistently with that, where I say preserve evidence and digital records, that is pretty important, because inevitably if you have a client who is issued with an infraction notice in a doping case, they will be asked to attend an interview. They can be compelled to attend an interview. They will be asked to produce their telephone and their computers, and they'll be assessed to consider evidence. Now, the worst look, and it happens surprisingly commonly, people say they've lost their telephone, they don't have their telephone. In one case, someone said, well, I've obtained the assistance of a retired Secret Service member from a foreign country to permanently wipe my telephone. It's odd that they would tell you that, but when they do, it sets a very bad tone for trying to deal with the ongoing process in any way that can end in a result other than a bad outcome for your client. So do preserve that. Now, I'm just looking at the time, and I'm going to deal with disciplinary complaints really quickly by just focusing on a couple of facts. And this is, if you forget anything about tonight, just if you're for a sporting organisation, please deal with disciplinary complaints. It might be complaints about selection, it might be complaints about bullying, harassment, in a way that's proportional to the complaint. And that works both ways. If you get a complaint about serious child protection issues, it's no use referring that to some subcommittee of your board. Tell the police or tell the Department of Justice. They will do an investigation. Conversely, you're very likely as a sporting organisation to get complaints about why my 11-year-old daughter wasn't selected in the rep team, or why somebody is not treating my child the way that I want them to be treated, for example, by showing them enough respect or something like that. Do try to consider alternative ways other than contested arbitrations, which is what these cases often end up in. And if that means someone from the national sporting organisation visiting a particular club trying to mediate a dispute, that is time well spent for disputes which can be triaged at an early stage as being relatively minor. The last thing I'll say before I do be quiet, because I'm conscious of the time, is if Jackie goes 2 slides forward, the other thing you should remember is that often in kind of off-field disputes, facts are more important than law. And so spend your time investigating, getting to the bottom of facts, rather than dreaming up difficult and complicated legal arguments. And the best example that I can think of that is a doping dispute which was initially heard, a high-profile doping dispute, initially heard by an internal tribunal of the sport. The finding was not guilty. There's a right of de novo review that went to the Court of Arbitration for Sport. The finding was there that the players had infringed the anti-doping regulations. The only difference was the evidence that was available on the second time around, because some very enthusiastic, active solicitor decided that they'd chase a rabbit down a hole, and they went to Melbourne University. They scrolled through temp files that were kept on molecular spectrometry machines. I don't even know what molecular spectrometry is, but she scrolled through the temp files, she copied them, she sent them off to analysis to the United States, and that showed that the substance in question was a prohibited substance. And we only had that evidence on the appeal. We didn't have it at first instance. So that was far better than any of the legal arguments that we raised. It was someone on the ground finding out the facts. That, I think, is all I will have time for. I'm going to hand over to Katherine.
Oh, thanks, Patrick. I'll obviously just to remind you, there'll be a bit of time for questions at the end. We can explore some of those issues. One issue we possibly can't explore that always intrigues me is how many double-strength short blacks one can consume before you're in danger of breaching doping prescriptions. But look, a brief introduction to Katherine. Katherine is, like myself, also a member here at Level 22 Chambers. Katherine has practiced substantially in administrative law, and she has done significant work in the area of incorporated association and clubs, particularly in the context of sporting associations and clubs, which is what she'll be focusing on tonight, as well as a practice in sports law. Katherine also is proficient in sport itself, well known for her tennis prowess. She's laughing modestly, I tell you. She's well known for her tennis prowess and also I'm informed spent a number of years as a gymnastics coach, so I'll hand it over to Katherine now.
Thank you very much, Ivan. Mr. Robert McClelland first became a member of the Burning Palms Surf Lifesaving Club more than 40 years ago. From the time he joined, he was actively involved in carrying out beach patrols and in competitions between surf clubs. After 20 years or so, his involvement in the more physically demanding activities of the club was curtailed, but he continued to be involved in fundraising and in the administration of the club. On 15 July 1995, a special general meeting of the club resolved to expel him. This is a part of paragraph 1 of the judgment of Justice Campbell in the case of McClelland and the Burning Palms Surf Lifesaving Club. And I've read it out to illustrate the point that there are very real human consequences of decisions that are made by sporting clubs to expel people from their membership. Involvement in these sorts of clubs can be a significant part of people's lives. It can extend over generations within families and is often done in a volunteer capacity. And yet, these decisions, carrying the significant personal and reputational consequences that they do, are typically made by committees of lay people. They may have little knowledge of the procedural strictures they're required to follow, the limits on their powers, or the requirements of procedural fairness, which ordinarily apply to their decision-making. Now, this is not to be construed as an encouragement to litigate disputes between clubs and their members. And that's particularly so where the constitution of the club will typically provide mechanisms for internal dispute resolution, and where the former members will likely want to be reinstated to their membership. But it's important to recognise at the outset that these disputes shouldn't be too readily characterised as trivial. They are properly justiciable in the courts, and in particular the Supreme Court of New South Wales, where equitable relief is being sought. If I could go over to my first slide, I've set out on this slide the structure of my presentation. So firstly, I'll outline some of the relevant features of the New South Wales legislation. And I do that to set the context of the second topic I'll discuss, which is a relatively recent decision of the New South Wales Supreme Court. And I'll use that as an example to illustrate the approach that was taken to running those proceedings and some of the issues that arose. And thirdly, I'll make some brief concluding observations. Now, I note at the outset that I'm concerned only with sporting clubs that are incorporated associations under the New South Wales legislation. Sporting clubs don't have to adopt that particular structure, and the Act is not limited only to sporting clubs. It covers any sort of association, such as social clubs, musical societies, and religious organisations, for example. So over to my first slide. The New South Wales legislation is the Associations Incorporation Act. It's administered by New South Wales Fair Trading, and if you want to go on their website, there is a register of New South Wales incorporated associations that you can look at. An incorporated association under the Act has its own legal identity separate from its members. It's a legal person. It can enter into and enforce contracts, can open a bank account, it can sue or be sued, and it continues even though its members may change. Now, every incorporated association must have a constitution, and that needs to address the matters that are referred to in Schedule 1 of the Act. New South Wales Fair Trading has prepared a model constitution, and it covers all of the matters that Schedule 1 requires. You can find it in Schedule 3 to the Associations Incorporation Regulation 2022. Now, an association can either adopt the model constitution or it can adopt its own. If the association's constitution fails to address a matter that is outlined in Schedule 1 of the Act, the model constitution will flow in and apply for that particular matter, and it forms a part of the association's constitution. The constitution of the association is a contract, between the association and its members who agree to adhere to the provisions of the Constitution. The way that the courts therefore interpret the association's constitution is by reference to principles of contractual interpretation. Broadly, this involves giving meaning to the words used, construed in their context, as evidence of the objective intention of the contracting parties. But in relation to incorporated associations, the courts tend to give a greater emphasis to the text in construing the Constitution. And that's because it's not just a record of a private bargain, but it is a document that has a public dimension and is relied on by third parties. Now, as I've said, the Constitution needs to address the matters in Schedule 1 of the Act. Without being exhaustive, they include membership requirements, entrance fees, the procedure, if any, for disciplining members, including appeals, the procedure for resolution of disputes, the composition, functions and processes of a committee, and the procedure for calling and holding meetings. If I could go over to my next slide now. This slide sets out Clause 7 of the Model Constitution, and this is the provision in the model that is concerned with disciplining members. You'll see that it refers to the committee, which is a body comprising of elected members responsible for controlling and managing the affairs of the association. Back at Clause 7, the committee is empowered, as a matter of discretion, to expel a member if certain preconditions to the exercise of that power are satisfied. And they are, in summary, the existence of a complaint concerning certain things, the giving of notice and an opportunity to respond, and the committee reaching a particular state of satisfaction. Now, with respect to expulsion decisions in particular, the courts have held that the power to expel from an incorporated association is one where the procedures laid down by its constitution must be strictly complied with. Clause 8 of the Model Constitution confers a right of appeal against a disciplinary decision, and that appeal is to the members in general meeting. Over to my next slide. An individual can take action against a member or the association if a breach of the Constitution has occurred. The remedies for breach in terms of proceedings in the courts are a declaration, for example, as to whether or not someone has been validly expelled or as to whether or not there's been a breach, an injunction to reverse or restrain the breach, and potentially damages as monetary compensation for loss caused by the breach. Urgent interlocutory relief can sometimes also be granted, for example, to restrain the holding of a meeting or to maintain a person's member status so as to permit them to compete at a sporting event. With respect to damages as a remedy, membership of a local sporting club often doesn't confer any expectation of economic reward. Rather, it's done for enjoyment and recreation. So a breach of the Constitution leading to the expulsion of someone in that scenario is more likely to lead to distress, vexation, inconvenience and the like. However, non-economic consequences of this kind are potentially compensable by damages, provided the contract, that is here the Constitution, is one in which the other party has undertaken to provide enjoyment or to avoid vexation and the like. And a case that illustrates this proposition is Rose and Boxing New South Wales, which I've cited on the slide. And there, Justice Brereton, as well as issuing declaratory and injunctive relief, awarded Mr Rose $4,000 in damages on the basis of the vexation and disappointment that had been occasioned to him by his exclusion from refereeing boxing in New South Wales for nearly 2.5 years, consequent upon the making of an invalid expulsion decision. Over to my next slide now, and having set out that framework, I'll move on to discuss my case example. There are 3 judgments available online in relation to this particular matter, and I'm going to speak to the 2 that I've identified on the slide. The third relates to interlocutory issues. So the facts in short are that the Australian National Sports Club Incorporated, or ANSCI, is a sporting club. It's on Punchbowl Road in Lakemba. It caters to children and adults, and its main sport is soccer. In 2017, a group of 3 life members of the club made a decision to remove the club's management committee, and they formed what they called an interim caretaker committee, or ICC. And the ICC then decided to expel 19 of the club's members. As emerges from the 2021 judgment of His Honour Justice Raine, the members of the ICC held concerns that the 19 plaintiffs were engaged in activities contrary to the club's interests, and they related to their association with a person named Sheikh Shady and the United Muslims Association of Australia. An important factual feature of this case was that ANZCI had its own constitution and it hadn't adopted the model constitution. Now, the ANZCI constitution said that disciplinary actions were to be undertaken in accordance with a procedure identified in a policy and procedure manual. However, there was no evidence from ANZCI that such manual was ever created or circulated. And the proceedings took place in 2 stages. If I could have my next slide, Jackie. The first stage involved a hearing on separate questions, and they were whether, as a matter of contractual interpretation, ANZCI's constitution contained 2 implied terms, which were referred to as the expulsion term and the fairness term. The expulsion term was about the grounds on which a general member was permitted to be expelled. And the language used in the implied term, which the plaintiffs pleaded, was derived from the grounds on which a complaint was able to be made under ANZCI's constitution. Now, I note there that the clause in ANZCI's constitution was very similar to the model constitution, clause 7, that we looked at before in relation to the grounds on which a complaint can be made. And His Honour held that the expulsion term was implied because of the express wording of the terms of the constitution, and in particular that clause concerning the grounds on which a complaint could be made. So in other words, it was an implication derived from the text of the contract, being the constitution. The fairness term, which the plaintiffs pleaded, was that it was an implied term of the constitution that no general member would be expelled from the club without first being afforded procedural fairness. And His Honour held that, yes, that term was to be implied in law by reference to the nature of the contract, that is, the constitution. And in the absence of express provision to the contrary, it was implied that the disciplinary provisions of ANZCI's constitution would be exercised in accordance with the rules of natural justice. So on to my next slide. The second hearing concerned the substance of the dispute, so whether there was a breach of the implied terms that had been found to exist in the constitution. Now, there were 18 plaintiffs in this case. One of the 19 had discontinued. And by consent, the case was determined by reference to 3 test member plaintiffs. What happened was the plaintiffs were divided into 3 groups. They were factually similar in terms of the conduct alleged. And from each group, a test plaintiff was chosen. One was chosen by the plaintiffs, one the defendant, and one by His Honour. And the 3 chosen were called Yusuf Kabara, Bassam Barake, and Khaldoon Musa. The parties then agreed that the decision for each test member plaintiff would determine the outcome for the respective group members. And the issues in the substantive proceedings were centred on whether the ICC had power to expel at all, whether the ICC had breached the expulsion term, and whether it had breached the fairness term. In relation to the power to expel, His Honour held the ICC did not have that power at all, and therefore the expulsions were ultra vires the Constitution. Now, the resolution of this issue was very fact-specific, so I'm not going to go into it in detail, but it highlights the need to pay careful attention to the composition of the decision-making body and the existence of and prerequisites to the power to take disciplinary action. On the expulsion term, His Honour examined the conduct alleged to have been committed by each test member plaintiff and whether it satisfied the requirements of the implied term. Now, this exercise somewhat approached, or in fact involved, a review of the merits of the expulsion decisions by reference to findings of fact that His Honour made on the conduct alleged and whether it fell within the scope of the implied term. This is probably, I think, a feature of the way in which the parties pleaded their respective cases and is not a common approach in terms of the authorities that I have reviewed. His Honour found in relation to Mr Kabara that the expulsion term had not been breached. Mr Kabara was found to have established a competing soccer club. However, the expulsion term was held to have been breached with respect to both of Mr Barake and Mr Musa, in circumstances where the conduct alleged to have been committed by them was trivial, was found not to have been proven to the extent alleged by the club, and was not capable of being characterised as sufficiently prejudicial in order to satisfy the expulsion term. On to my next slide, and I will deal now with the fairness term. Now, His Honour found this term was breached with respect to all three test member plaintiffs. He relied on a number of matters, cumulatively in so finding. They included that one of the three ICC members, so that is the decision-making body, and her name was Ms Tabber, one of the three, Ms Tabber, was the person who had made the relevant complaints to the ICC about the test member plaintiffs. Ms Tabber had also instructed solicitors to commence earlier proceedings in the Supreme Court against persons including the three test member plaintiffs. That was in 2017. Ms Tabber had given instructions in those proceedings to bring a contempt charge against Mr Kabara. Now, Mr Kabara had made serious allegations against Ms Tabber in 2017 in writing, and there was a very strong personal animosity between the two. Another ICC member, Mr Dasuki, gave different reasons in his evidence for the decision to expel each of the test member plaintiffs than those which had been put to the test member plaintiffs in three show cause letters issued by the ICC. So the letters putting them on notice of the allegations and identifying the basis of the complaint were different to what Mr Dasuki said in his evidence to the court were the reasons for decision. His Honour held that the matters referred to revealed that the evidence of what the ICC had relied on was internally inconsistent and was inconsistent with what was stated in the show cause letters. There had been a failure to put to the test plaintiffs the matters that the ICC felt warranted their expulsion. And the ICC had failed to consider the question of whether to expel the test plaintiffs in an honest and unbiased way. Furthermore, Ms Tabber had acted as a prosecutor and she should not have been taking part in the ICC's deliberations at all. Therefore, declaratory relief was granted. This is not a case in which damages were sought. On to my final slide. Avoiding disputes or minimising the scope for them to escalate significantly, I think, starts with the laying of proper foundations at the time of establishing the association. Careful consideration needs to be given to the terms of the association's constitution. Certainly, it can be advantageous to adopt the model constitution. The rules serve an educative function, it's cheap, and it's administratively convenient. There's also no need, of course, for the association to check that its constitution complies with the minimum statutory requirements in terms of content. However, the model rules adopt a one-size-fits-all approach, and they may not be completely suitable to the needs of the individual association. Decision makers sitting on committees must understand that they're not at large in their decisions. It's important to ensure that the decision maker in fact has the power to make the decision and does so in accordance with procedural requirements. The authorities in this space clearly establish that the requirements of natural justice apply to disciplinary decisions unless they are expressly excluded or excluded by clear necessary implication. The model constitution provides somewhat of a partial codification of the requirements of the natural justice hearing rule at common law. And as we saw in the case of Ansky, the second element of the natural justice hearing rule at common law is concerned with bias, including a reasonable apprehension of bias. So a decision maker who's been personally involved in the facts forming the complaint alleged against the member may not be suitable, subject perhaps to issues of necessity, to sit on the committee determining the disciplinary decision. Committee members aren't generally lawyers, and they're certainly not generally administrative decision makers. And yet their decisions are scrutinised by the courts in quite a similar way to what we see in the scrutiny given to statements of reasons given by administrative decision makers making decisions pursuant to statute. Now, those administrative decision makers use templates and precedents for convenience and consistency, and also to guide them in the correct application of the law. I think there's certainly a role for practitioners in this area to assist incorporated associations in developing a suite of these sorts of documents for use by their committees. That was all I wanted to say by way of concluding observations. Thank you very much. I'm happy to take any questions.
Okay, thanks. Thanks, Catherine. We might save the questions till we're finished. I will finish off the formal part of the presentation. And when I say the formal part of the presentation, I'm hoping to move more to a bit of a fireside chat vibe with my discussion. But what I'm looking to do is just give you all just a bit of a taste of how matters generally proceed before sporting tribunals in respect of, from a practical perspective, in respect of what we might call on-field matters. Now, my experience in the sports law area is, as I think I touched on before, predominantly in respect of the world game. I've heard it referred to as soccer. I call it football. I am regularly instructed by Football Australia in respect of matters arising out of the principal competition, the A-Leagues, I use a plural because it involves the A-League men and the A-League women. I appear as disciplinary counsel before the relevant tribunal, which is called the Disciplinary and Ethics Committee. As an aside, I do occasionally appear as a tribunal member in a separate tribunal in terms of matters in the competition in New South Wales, a rung below with the New South Wales Football Association, but that occurs from time to time, and it's a different perspective, which we'll perhaps discuss another time. So disciplinary counsel, my role is somewhere between prosecution and counsel assisting, I think. The hearings proceed in accordance with the guidelines, or in accordance with the A-League's disciplinary regulations that set out all the relevant rules, and they, to the extent that applicable, they incorporate the laws of the game as prescribed by FIFA, the worldwide organisation. From a practical position, what happens every weekend after a round of games is that a body comprising of 3 people, usually a couple of ex-referees, perhaps an ex-player, called the match review panel, and they review all the events that took place in the matches over the weekend, all the red card events, and any incidents where they consider a red card ought to have been given, but it missed the attention of the referee. I hasten to add, since the introduction of VAR, video-assisted referees, about 4 years ago, those are very rare, because if it's missed by the on-field referee, it's generally picked up by the video referee. So what happens then, by and large, the match review panel determines the sanction that applies depending on the nature of the offence, and they have the regulations that are referred to have a table of offences which gives them guidelines, and they're quite broad guidelines. And to give you an example, a regular foul which is deemed to be serious enough as to warrant a red card, a sending off as opposed to a caution, a yellow card, described as serious foul play when challenging for the ball, that has a prescribed minimum penalty of the mandatory match suspension, whereas slightly more serious incident called assault on a player, which involves what's described as violent conduct, that's the minimum there is the mandatory match suspension plus 1 more. And then, of course, they go up. They can go up from there depending on the nature of what occurs. the exception to the matter being dealt with by the match review panel is where the matter is deemed to be so serious that they say that they consider this could involve a penalty of 4 games, a 4-game suspension or greater, in which case they send it straight to the committee, straight to the tribunal, as it were. An example is spitting. Now, spitting is it's a funny business, spitting, because let's be honest, it's gross, but and everyone hates it, and it gets a very emotional response. The reality is, though, that a studs up challenge to the shins can do a lot more damage than spitting. But the average suspension for a studs up challenge to the shin that can break a leg, usually if you're unlucky, you might get a 3-week suspension. Spitting is an automatic 6-week suspension, and that's actually determined by FIFA under the international rules. That's how it's regarded, and I find it interesting. And I've spoken to players and others involved in the game, and they'll generally agree that I had one player tell me that he'd prefer to be punched in the face than spat on. So I guess that's the rationale behind it. So and I've had to deal with a spitting case, and again, by the time in terms of that situation, you might get an argument as to, well, yeah, I spat, and you can generally see it in the video. But I wasn't intending to spit on the person, or I just spat near him, or then this, that, and the other. And the most amusing thing about that was that the counsel representing the player didn't want to use the term spitting, and tried to because he felt that just didn't like the word. So he described what came out of his client's mouth as expectorant, which is a term I'd not heard before. Anyway, the tribunal didn't buy it. It didn't affect them whatsoever. So what normally happens, though, as I say, aside from those circumstances where the matter goes straight to the committee because it's deemed to be serious, if a player is unhappy with the sanction that the match review panel has provided, then they appeal to the Disciplinary and Ethics Committee, which I mentioned before. Now, that committee generally comprises 2 lawyers and a former player. Now, the ex-player is actually very important to have, because they have a feel, they've played the game at a professional level. More often than not, it's someone who's not only had extensive experience, but generally the people that they get are former Socceroos, people that have represented Australia. And the 2 lawyers are more often than not senior counsel. Anthony Lacerdo, Lachlan Giles, they often appear. Sometimes it's a solicitor as well. And most cases are not especially exciting. I find them interesting enough, but in most cases, you've got a situation where, as I say, it's that kind of tackle that I described earlier, or something, an elbow, a swinging elbow or something like that, and the player's been potentially given a 2 or 3 game suspension. They think, the player of the team, his club, think that's too harsh, and then so they'll appeal to the committee. Now, the committee is, under the regulations, has got a broader discretion than the match review panel. The match review panel, when they view what's happened and they make their sanctions having regard to the table of offences, they consider solely the offence. But under the regulations, the committee can take into account other matters. They can take into account the player's disciplinary record. So if someone's got an excellent disciplinary record, then that stands them in good stead. It's also gone the other way as well. And they can take into account character, and that character reference. And another factor said to be relevant is remorse. Did they apologise afterwards? How did they react? It's not helpful, for example, if they continue arguing with the referee and to kick the sidings as they're going out. In each of the cases, when they go to hearing, it's virtually always a situation where it's not a retrial of what's occurred. Once it gets to the Disciplinary and Ethics Committee, assuming it's not one of those cases that's been sent straight there, assuming it's something that's been assessed by the match review panel, then the red card is a given, and the mandatory one match suspension is a given. The issue is what the sanction ought to be. Should it be greater than the one match? And if so, what should it be? So the most important evidence in virtually every case is the video footage. Ever since the introduction of the video-assisted referee, we now have extensive video footage of every incident from multiple angles. It's a given that a case always looks worse in slow motion. And in that, as I said, that's where it's useful to have the former professional player on the tribunal, because they can have a feel for that scenario. In terms of the other evidence that you'll get invariably in one of these hearings, there's always a referee's report. Sometimes there's more than one, if more than one referee witnessed what happened, but the referee will generally say what he or she saw and why he or she gave the red card, or etc. Or, now it can include, I saw the incident live and I was called over to the video and I saw, in fact, the tackle was worse than I originally thought, etc. So that includes that. Now, one thing, and I'm interested to hear, Patrick, I know that you've had involvement in RL. Certainly, one thing that they do not allow in football matters is referees to be cross-examined. You take their statement, and that's it. Is that the case in the league?
In an era of videos, we have about 8 angles of every incident, and referees are not called to give evidence anymore.
Yeah, well, that's never been allowed, and sometimes, when the referees report, the players will dispute what is in the referee's report, but it's there. And sometimes, for example, if the referee says they refuse to leave the pitch immediately, or you usually can see that, or if there's a description of dissent or something like that. So that's incident. Anyway, as a matter of policy, they don't want referees to be cross-examined, and I can understand why that's the case. So generally at a hearing, what will happen, they are now mostly conducted via Teams post-COVID. But generally at a hearing, what can happen is that you've got that basic evidence in terms of the video footage, and which there's a lot of focus on. I, as disciplinary counsel, will speak to the Players' Council. Often that's counsel appointed through the Players' Federation, their union. We'll also speak to it. Generally, the player will have given a statement as well, and the player will generally give evidence, and I can ask a few questions, and the tribunal can ask a few questions as well. You'll have the evidence of the disciplinary record that might be relevant, character references. It's very rare, but there might be instances where other players might give evidence. I had a case, a very involved case some years ago, where there was and this was one that went straight to the committee because it was potentially a very serious matter. The allegation was use of discriminatory language of a racial or religious nature. I mean, I don't make light of that at all. What I always find interesting about those cases is that it's not any level of horrendous abuse, of verbal abuse, is acceptable, but so long as it's not of a racial, religious, or ethnic nature. So it wasn't in dispute that abusive language was called. It was used. It's just a matter what was the word used before the particular word was used. And he said the player charged said he'd called him an ugly, whereas the other player said it was of a racial nature. That's a segue in a sense to my next point, which is generally speaking, in terms of the rules of evidence that apply, and of course there's fairness as well that apply, but broadly speaking we have the civil standard. But if it's a serious matter, like that allegation, it was accepted that, that the tribunal would have to be comfortably satisfied, within that framework in order for the charge to be established. And in that particular case, that was a case where a couple of teammates were called to give evidence. It was a Sydney derby about 6 years ago. There was a crowd of about 40,000 people at Allianz Stadium. There was a lot of noise. It was getting towards the end of the game, and when this interaction occurred, no other player had heard it. The referee hadn't heard what was said. One or two players gave evidence. They weren't even cross-examined, but they gave evidence as to what they saw, the immediate reaction of the player the insulted player or the victim, the immediate reaction. But ultimately, the tribunal found that they were not comfortably satisfied that the words were used, and it was very much a he said scenario. They accepted that the victim, if I can call him that, believed he was racially abused, but they weren't willing to make a finding. They weren't comfortably satisfied that the words alleged were actually used by the other player. So and in a sense, that's not a surprising outcome given the nature of what was alleged, and ultimately that's the way it went. That was one interesting case that I involved with. So as I say, most of the hearings really proceed without too much controversy. The players, they proceed in a much more professional manner than they used to. Now, the A-League competition's been around, maybe about 14, 15 years. And in the earlier days, I wasn't involved from the beginning, but maybe after about 4 or 5 years I was involved. But now players will invariably be represented by legal counsel. It's usually, as I say, someone appointed through the Players Federation. Sometimes couple of the bigger teams like Sydney FC or Melbourne Victory will have their own lawyers that will represent the player. One misses the heady days when there were some pretty cowboyish clubs, including like Gold Coast United, that was owned by Clive Palmer. And Big Clive used to do the advocacy work, in inverted commas, for the clients, and that had some moments.
In the NRL tribunal, most clubs use lawyers. There's a few people who do. There's some clubs who don't. Often it'll be either the football manager or the coach. And my experience is they're better at it. I wouldn't pay for a lawyer, including myself, to be there. At least in the NRL tribunal, 2 of the panel are not lawyers. Yeah. And the tendency for a lawyer to stand there and try and tell someone who's played 30 games of State of Origin how to play rugby league is just embarrassing. And it's far better to have a coach or a football manager just plead the case. In most cases are decided on the video anyway. Well, that's very true. Kind of directness sometimes to the... Yeah.
Well, we obviously sometimes we have used precedent cases from previous decisions, and you try and go through the analysis. But and certainly I guess I use the extreme example of when Clive Clive Palmer would appear, and it was absolute chaos when Palmer, and just to finish off with I did promise a war story. I'll finish off with this situation where Clive was, this is about, I don't know, maybe back in 2009, 2010, something like that. And his player was a guy called Steve Pantelides. He played for Gold Coast United, and he was jostling with someone, I think he was at Melbourne Victory at the time, Robbie Cruz, former Australian international, and he elbows Cruz in the head. Cruz goes down. I mean, and you could see it was done with quite some force. And so Clive's defence on this was self-defence. And he explains it, that, well, you know, that he says Cruz, you know, he was jostling with our player and he had to do that to set himself free. And his big line was, and as an individual, Mark Klein is entitled to defend himself, whether he's under attack from Robbie, whether he's under attack from either Al Qaeda or Robbie Cruz, he's still entitled to defend himself. And we're just looking around. At that point, he was appearing via video from at the Gold Coast, and I was in the tribunal room with the members of the committee, and we're looking at each other quizzically, saying, what, did he just say what we thought he said, you know? So, yeah, you get, that adds a bit of colour to it. But, yeah, so look, that's, looking at the time, we've actually hit 7 o'clock. I'm sure that if there are some questions, I think there are. Jackie, tell us about it.
We've got an online question. It says, have tribunals altered their approach to incidents that cause concussive trauma? Are governing bodies using these tribunals to insulate themselves from future liability for athletes who sustain CTE? I assume you all know.
In my experience, the answer to the first question is yes. The answer to the second question is no, not that I am aware of. So yes, at least in the NRL judiciary, issues of concussion are taken very seriously. They come up all the time, including last Tuesday night. And the approach the game has taken to that is quite different to how it might have once been done. And in a whole lot of other areas, I know rugby union is the same. As for the second question, I'm probably not close enough to any sports administration body to know motivations, but there's nothing that I've seen to suggest that there's some kind of desire to use an independent committee as a patsy to avoid liability. I frankly doubt that it would be a very good defence, but it's nothing I've seen.
I can't add anything to the second issue. The first one, certainly, obviously, concussion does arise in football, not, I think, as commonly as in rugby league or union, but the one occasion where I've made a submission that a certain sanction is warranted and where the committee has actually gone above and beyond what I've recommended was a case involving it was actually the A-League Grand Final a few years ago, and in the dying minute of the game, a goalkeeper went to grab the ball, and an attacker on the other side essentially went for what looked like a karate kick, and his boot made contact with the goalkeeper's head, and he got an immediate red card. That's dangerous play, and regrettably that player had prior as well, and also had prior in terms of incidents where he made contact with his opponent's head. And I thought it was serious enough to warrant a submission that a penalty of 6 to 8 weeks was warranted, and the tribunal actually gave him 12. So it took it very seriously. Yeah. Any questions here?
I have a question. I won't unnecessarily prolong it, but about cross-examining players in tribunals and how you approach that, because it's something that's had a bit of media reporting this year in other sports that we're not involved in, but also I I'd just like to hear how you go about it.
Yeah, there's very little scope for it in the usual hearing because, as I say, there's generally not, as you know, you yourself said, it's all in the videos. There's not a lot of contested fact. And then, so sometimes it's about their intention. Invariably, when they go in with their boot high and their studs showing and it makes content, and they come in very late and say, oh, I thought I could win the ball, you know, and the ball's gone. Well, it's especially when you watch it on slow motion, they were nowhere near the ball. But, and it's something you can challenge to a degree. I very rarely am aggressive in my cross-examination. I usually, but that's possibly also indicative of my general style. I think, you know, that I generally adopt a catch more bees with honey approach. But, you know, there has been occasions, that other case going back some years involving the alleged racial dispute, I had to put it to him that he said it and, you know, dealt with it like that. And also you're sort of probing in terms of the, you know, when they go in for a late tackle, you know, sort of probe as to whether, you know, well, you were fired up, were you, because you were down and this, that and the other. And so, but yeah, other than that.
Because I just have visions of some kind of soundbite of cross-examination being reported in the media, and eventually that might, you know, detract from what is the purpose of the hearing. It's not about counsel assisting calling someone a coward. Yeah. It's about, was it a high shot or was it not? Yeah. And I just think that if you're particularly representing a sport as counsel assisting, dial it back. Yeah. Sure, you've got a prosecuting role, but for most of these things you can do it without permanently injuring anyone's reputation. Yeah. So,
oh, look, I think you're absolutely right, and you know, it's not about grandstanding, to use another cliche, sporting-related cliche. It's really about, you know, as you say, demonstrating that the offence was caused, if necessary, or what the appropriate sanction ought to be.
How are we for time?
Slightly over.
Okay,
Was that the only question we had?
Okay, well, look, we can wrap this up. Thanks, everyone, for participating. Thank you, everyone who's joined us online. Thank you for those who have attended in person. We appreciate it, and hope to see you at our next seminar. Good evening.